Hi, this is Attorney Jay Farrow, and I'm here today to talk about verbal contracts. Now, many people think that the only enforceable agreement is in writing. I mean, you've heard it, get it in writing, or did you get it in writing? Well, fortunately, it's not the case in the law. You can't have a verbal contract with a person. You can have a verbal contract with a corporation. Two corporations can have a verbal contract with one another. I mean, there are some exceptions to this. However, the main thing I wanted to share with you today was that a verbal contract is something that you can enforce. The reason why I wanted to talk to you, though, is that many people don't want to enforce their verbal agreements because they don't think that they have any rights. Well, the components of a contract, whether it's verbal or written, are identical. You have an offer, you have an acceptance. You have to have some type of consideration being exchanged between the parties, and then there's got to be performance. Now, if one of the parties doesn't perform under that scenario, whether the contract be verbal or written, there's going to be a potential for having a breach of contract action in the state of Florida. Now, there are these exceptions, and the exceptions fall into something what's called, and it's a industry term, statute of frauds. And it's ironic because the exceptions really don't have anything to do with frauds, but what the statute says is that there are about 7 different types of contracts that need to be in writing. Contracts that are going to last over a year, a marriage contract, contract for the sale of goods over a certain amount, and each state is different when it comes to that. A real estate contract is another contract that needs to be in writing. So there is no such thing as a technical oral lease. Now, that doesn't mean that you can't enter into an oral lease or something like that with a landlord. As long as you guys are performing, you don't need a contract necessarily to have like certain scenarios happen. But the key is this: whether you've entered into a written contract or a verbal contract, evaluating whether or not you have a claim is something that you should discuss with a lawyer, especially when it comes to the verbal contract, because there are the exceptions to whether or not a verbal contract is enforceable. But going over the contract or the agreement with an attorney in the circumstances, there might be some other things going on when there's a verbal contract that might lead to other causes of action. When one party makes a false representation to have another party act, perform a service, or turn over some goods, and those representations, again, were false, there might be some types of fraud claims when you go down that rabbit hole. But most importantly, if you do have a verbal contract with somebody, you're not out of gas if they didn't perform. I mean, you can actually go to court and enforce these things, and it's the best thing to do is get a lawyer that is familiar with contracts and contract law to go over it with you.